Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to tell you about 212H waiver. It's a very interesting, exciting waiver that can help both permanent residents and non-permanent residents to waive certain crimes, including sometimes an aggravated felony. Not every aggravated felony, but an aggravated felony that also is a crime of moral turpitude. 212H waiver is available for those who are seeking admission into the United States in connection with an application for an immigrant visa or for an adjustment of status. Certain crimes make people inadmissible, meaning that they cannot become green card holders in the United States. But there are certain waivers, like 212H waiver, that may help them. 212H waiver waives crimes of moral turpitude, convictions, no matter how many, related to the crimes of moral turpitude. It waives convictions related to prostitution. It helps those who either have a qualifying relative who will experience extreme hardship, or those who committed the offenses more than 15 years ago and now can prove rehabilitation. There are some other situations that 212H waiver can be helpful. This video is about when 212H waiver can be applied for. Well, first of all, somebody who is seeking admission can file for 212H waiver after he or she was found inadmissible. For example, you're sponsoring a relative who is overseas and the relative was found to be inadmissible due to a crime of moral turpitude. Maybe there was a theft offense, burglary, embezzlement, anything that be considered moral turpitude. Then the person has a chance of filing for 212H waiver. 212H waiver sometimes is available even for green card holders. For example, a green card holder committed a certain crime and then traveled outside of the United States. At the border, the person was found his admissibility was questioned because the CBP agent saw that the person committed a crime. Now, a permanent resident typically will not be considered as a person seeking admission into the United States when he or she is returning back from a trip abroad. But when the person committed a crime, certain crime that makes him or her inadmissible, when they're trying to get back into the United States, that would be considered as seeking admission. And the person usually would be placed in removal proceedings and will be able to apply for 212H waiver without having to submit a new application for adjustment of status. It's very, very important. So when the person is charged as arriving alien, he or she can file for 212H waiver without the need of a new adjustment of status. But here is the situation. Somebody committed a crime, and by the way, the situation happens very often. Somebody committed a crime, traveled back and forth numerous times, never had a problem, came back into the United States. 5 years later, after the person came back, now the immigration would like to deport the person and charge him or her as being deportable alien, not as arriving alien. The person will not be able to file for the waiver without a new application for adjustment of status. There is some case law actually that says otherwise, but Board of Immigration Appeals, I believe in 2013, ruled exactly what I told you. And I know that there are some circuit courts that ruled previously differently, but the majority view, I would believe, would be that the person cannot file a standalone waiver if he or she is not an arriving alien. So once the 212H waiver is granted, it waives the crime, and here is an important thing. It may even waive an aggravated felony if that crime is also a crime of moral turpitude. Who disqualified from the 212H waiver? Permanent residents who has not accumulated 7 years of presence in the United States, and that 7 years is counted differently from cancellation of removal for permanent residents. That 7 years are stopped when the person is served with notice to appear. And those permanent residents who, after admission, after being admitted as a permanent resident, committed a crime, that committed an aggravated felony. So if you are a non-permanent resident and you committed an aggravated felony, you may still use the waiver if your crime falls under the criteria for the waiver. But if you are a permanent resident and you committed such a crime, an aggravated felony, you will not be able to use this waiver. Kind of unfair, if you ask me. But those challenges where people try to argue that it's unfair, they failed. Also, what's important is there is a difference between permanent residents who were adjusted their status to become a permanent resident in the United States and permanent residents who were admitted as such at the border. Those people, the last category, is the least advantaged or the most disadvantaged group, because basically all the bars will be applied to them. But sometimes when a person received the green card status in the United States opposed to at the border, they can still benefit from 212H waiver, even if they don't have 7 years, necessary 7 years, or if they committed an aggravated felony during the time after they became a permanent resident. So this is a 212H waiver. It can be compared sometimes with cancellation of removal. Sometimes when the person does not qualify for cancellation of removal and the person is a permanent resident, they may nevertheless apply for 212H waiver. And I have more about these two forms of relief on our website, www.shautsova.com. Thank you.